Last week's video, I outlined the 6 major business concepts in the comic book industry and how they relate to IP. The thing is, whenever you talk about any aspect of the comic book business, sooner or later, someone's going to start throwing the letters IP around. What exactly is IP? And why is it so important to comics? I'm going to use this video to explain what IP is, what IP isn't, how you create IP, and how you can protect the IP for your comics. So I'm an attorney, author, and business consultant with more than 20 years in the comic book industry. So I've spent some time with the concept of IP. Intellectual property, or IP as it's referred to, is regarded as intangible creations of the human intellect. Unlike real property, like real estate that doesn't move, and personal property, the material goods you can move, intellectual property focuses on the ability to own, control, and profit from ideas. Patents, trade secrets, and trade dress are all types of intellectual property, but they aren't usually relevant to comics. In this industry, your main concerns are copyright and trademark. Copyright, usually represented in the US with the Circle C symbol, is the intellectual property right protected by federal law for original works of authorship in any tangible medium of expression. In its most basic form, a copyright gives the owner the right to make a copy of their work, hence the name. But it also governs who can use or exploit the work for any type of financial gain. By contrast, a trademark, normally represented in the US with the symbol circle R, is a word, phrase, or symbol that identifies the source of the goods of one party from the goods of another party. Over the years, I've found the easiest example I can give a comic book reader to help them understand the difference between a copyright and a trademark goes something like this. Let's say someone who creates a story about a rich young man who survives a violent criminal attack and uses his wealth to acquire the skills and technology to fight crime as a vigilante. Let's also say he takes on a persona modeled after an animal associated with fear and the night. For the sake of this example, let's say this guy decides to use a bat. And he goes on to create a series of tools based on his symbolic totem that fans identify with by purchasing t shirts, posters, hats, and anything else that you can put a bat sticker on. Now, maybe you've heard or read a story like this in comics, TV, film, and video games dozens of times over the past 80 years. But as an example, it still works very well. There is a copyright created for every story of the masked crime fighter. The images associated with him and his story become trademarks, and those symbols can be put on anything and everything to help sell stuff. Now, whoever controls the copyrights and trademark to a particular IP decides how it will be used and who gets paid for it. Keep in mind, I didn't say whoever creates a particular piece of IP. In many cases, the creator is not the ultimate owner, and it is very easy for a creator to give away control over the IP they create if they don't understand the legal and business relationships concerning their creations. If you remember nothing else from this video, remember this. You can only sell what you own, and you cannot sell what you do not own. The big two, Marvel and DC, have built a multi-billion-dollar business on IP that they own but didn't necessarily create. Back in 1938, Jerry Siegel and Joe Shuster sold the rights to Superman to DC Comics for $130. As of 2016, the licensing rights to Superman, not counting the comic book sales, were worth more than $277 million. At the same time, Marvel defines itself as a character-based entertainment company whose entire value is based on characters created by thousands of in-house and freelance talent over the years. These comic powerhouses dominate the market because of what they own, not particularly because of what they made. Now, comic IP is based on ideas, but ideas by themselves can't be legally protected until and unless they meet some minimum requirements. Ideas gain the status of intellectual property at the point when you meet those conditions. I'm going to focus on copyright here, but the fundamental ideas are the same for trademarks. In general, there are 5 steps you need to take to create and protect your IP. First, record your ideas. IP requires that you what's known as a fixed medium of expression before it qualifies for any legal protection. So you need to transfer what's in your head into something else. You can write it down, you can draw it, you can record it on your phone. As long as it's your unique expression, you're headed in the right direction. Next, you have to make sure you own what you created. One of the major violations of intellectual property law is called infringement. Infringement occurs when a work protected by IP law is used, copied, or otherwise exploited without having the proper permission from the entity who owns those rights. For example, if you decided you were going to publish a space opera about a battle between an oppressive empire and a group of rebels that revolved around several generations of a family called Skywalker and their relationship to a semi mystical energy called the Force, you would be infringing on the Star Wars IP, and things would not end well for you or your book. As you're trying to figure out if anyone already owns your potential IP, you also need to give special consideration to your creative and work relationships. Depending on your employment contract for your day job, anything you create might belong to them. Depending on who you're working with to make your comic, anyone who works with you also might own a piece of your IP. In these situations, you need to resolve any potential contract issues before you move forward. The third step is to register your IP with the Library of Congress. The process is quick, easy, inexpensive, and in most cases, you do not need an attorney to file these registrations. One of the things I offer to members of CPI is a screen by screen walkthrough of the online copyright system to help facilitate this process. The one thing you don't want to do is mail a copy to yourself and expect copyright protection. The postmark on the envelope isn't going to help you. The only thing it's going to do is give the mailman something to do. And they already spend their days filling my mailbox with bills, so you don't have to worry about that. After your copyright is properly registered, you need to understand any contract that you sign and how it relates to your IP. As I said before, it's very easy for you to give up some or all of your IP rights in a contract. IP rights are transferred all the time in the world of comics, TV, film, and video games. If you get paid for your IP in the contract, then that's fine, as long as you got as much as you gave up. If you're giving up your IP rights without any compensation, then the whole process could be very painful for you. Finally, you need to monitor the market for infringement. If anyone uses your IP without paying you as the rights holder, then your IP rights are worthless. That doesn't mean everything you find online with a trivial similarity to your story should warrant a cease and desist letter. Infringement isn't always easy to prove, but if you're not looking for it, you'll probably never find it. Now, intellectual property is a complex and evolving field of law. It is impossible for me to explain everything you might need to know in a video, so this doesn't constitute legal advice. If you do have specific legal questions about your IP and you'd like to schedule a free consultation, you can find a link on the screen. If you'd like to find out more about the business and legal side of comics in general, you can join the Comics Publishing Institute with the other link on the screen. Until then, have fun with your comic.